You saw earlier, the Constitutional Court has found the former President Jacob Zuma's application that it rescind its earlier judgment ordering that he serve 15 months in prison does not qualify to overturn their earlier ruling. The judges said his argument that he had not been allowed to be heard by the court before being jailed did not hold water, as he had simply refused to make arguments in the court when he was invited to do so. Benedict Phiri is a lawyer, the founder and managing director of IusPrudentia Specialist Counsel. Benedict, good afternoon to you. Obviously, it's a long, lengthy judgment. There's a lot to go through, but it does seem the judges were actually a bit annoyed at the application.
I agree with you, Stephen, and I think I just recall the words of Justice Khampepe calling the application a monumental waste of legal resources. And then obviously, going along with that, Mr. Zuma has been saddled with a cost order. The Constitutional Court saying they'll deviate from the BioWatch principle, which usually allows parties to bring Constitutional Court challenges without being afraid of being labored with a cost order after that.
So, I mean, then they really are showing that there are, I mean, part of it is, the idea was that the former president, he said he hadn't been able to make an argument. I mean, his supporters kept making this claim that he had been detained without trial, and the judges have thrown that claim out as well.
Yes, the judges are really saying that, you know, the contempt jurisprudence in the country is tried and tested, and there's no basis for a suggestion that for the president to be sent to prison was without trial. Obviously, the circumstances of this case is that the president himself decided to put himself in this particular position, and once the horse had bolted and he'd been convicted to imprisonment, he then approaches the Constitutional Court for a rescission, which in fact is an appeal which is disguised as a rescission.
I wonder if the judges sort of have a right to be quite annoyed. I mean, they're judges, but they're human too. If I remember the timeline, so when the Zondo Commission first went to court, Zuma had a legal right to oppose it. He refused. He was then invited to make submissions about his sentence. He refused. Instead, he issued a public statement attacking the court. Then his supporters claim he did not have a fair trial. Am I wrong to think the judges are actually quite right to be annoyed at how they've been treated?
I think they are certainly quite right, Stephen. And I mean, you know, some of his defenses, the judges outrightly saying they are disingenuous. So, you know, he said that, for instance, the Constitutional Court in the previous judgment took into account hearsay evidence, which are the statements from his foundation. And, you know, the Constitutional Court saying this is completely disingenuous because, one, you spoke for yourself when you did and you spoke the way you did. And secondly, you have not sought to distance yourself from the Jacob Zuma Foundation. And then you come and say that, you know, we took into account hearsay evidence when we shouldn't have. You know, so absolutely every right to be annoyed. I mean, the argument around Justice Phiri and her having to recuse herself, the court again saying, well, you knew she was a justice who was going to hear this application. You had the ability to raise those concerns when you came, when the matter was served on you, and you kept quiet. And then you do it at the end when the horse is gone. So, you know, that annoyance does come through. And I think with reason too, Stephen, given the manner in which Mr. Zuma conducted himself in this litigation, and also that not being spared by the Constitutional Court justices as well.
I mean, there's a lot to sort of reflect on here, because there was the entire idea of a rescission application, and this is the first time I'd actually heard of a Constitutional Court ever hearing an application. Do you think the court was also today trying to send a message to other people they shouldn't try it, and they shouldn't try and make a rescission application unless they have a really strong case?
I think so, because, you know, we do have Advocate Busisiwe Mkhwebane's application, which followed hot on the heels of Jacob Zuma's application. And certainly, I think the court tightening up the test and saying, we're clarifying this so that it is absolutely clear that a rescission is really in exceptional circumstances, because as a fundamental tenet of the rule of law is that, you know, court orders are final, and once the court has issued its decision, it is final, unless there is an appeal body above that, in which case here there isn't, because the Constitutional Court is the apex court.
In a way, this whole issue also gets back to the rule of law and sort of politics. I mean, in a way, that is the story of the former President Jacob Zuma. Is this now finally the end of the matter? And I realize that we had thought before it was the end of the matter until this rescission application came.
Certainly, this should be the final end of the matter, Stephen. And I think Justice Khampepe calls it an end to the trilogy in her parting shots in the judgment. In her opening remarks, she says exactly what your sentiment is the irony of this matter is that it is about the rule of law. And to uphold the rule of law means that we cannot give credence to flimsy rescission applications which have no merit.
So, I mean, it does raise the question, why did they agree to hear it in the first place? This is, I mean, I scratch my head, and I try not to do that on Fridays, only on Mondays, but why on earth did they decide to hear it in the first place?
Stephen, I can only surmise that, it is about the stewardship of a sensitive matter in the country. And certainly at the last judgment, there was dis-ease around whether the Constitutional Court had done the right thing or had come to the right judgment. But I certainly, right now, believe that the Constitutional Court has given this matter its full ventilation. And I'm comfortable that, we don't have any other avenues that are open to Jacob Zuma's legal team, despite what his foundation may say. I'm certainly comfortable that the Constitutional Court has done this matter full justice.
Benedict Phiri, thank you very much indeed. Really do appreciate it, the lawyer, legal expert there. It's a fascinating story. I imagine there are going to be a few legal PhDs or whatever they're called in law when you become a doctor of laws in this particular issue. Benedict Phiri, thanks very much indeed.